The distinguished gentleman from Iowa, Mr. King.
Thank you, Mr. Chairman. I appreciate being recognized on the testimony of the witnesses and the professional opinion that you bring to the hearing here today. I'm listening to this testimony and this discussion, and I'm thinking about the class action lawsuits that stand out in my mind. And some of them may or may not fit into the category of this discussion here today. I'm thinking of the Pigford Farms issue, just one, and I think you'd all be familiar with that case, on down through the Love case, the Keeps Eagle case, the Garcia case. And I'm interested in an opinion of each of you gentlemen as to whether the executive branch should be legally allowed to enter into a de facto class action agreement without the oversight of Congress. And I turn first to the gentleman, Mr. Reddish.
Congressman, that creates a very sensitive question of separation of powers. I believe the executive branch has the authority to enforce the law as it sees fit, and if we're talking about the exercise of its authority in an individual case, to vest supervisory authority in Congress could be seen as undermining the executive power. So my tentative response would be I think that is not only appropriate, it may well be constitutionally required, but I haven't studied the issue closely, so I wouldn't like to commit myself irrevocably on that.
Okay. And Mr. Sobel?
I can make my remarks brief. I have no opinion on that subject. As far as I know, there are no procedural safeguards that need to be added to that situation. I'll leave it at that. Thank you.
Mr. Wiesner?
I am familiar with those cases, but I am much in the boat of Professor Reddish. I'm not sure I'm in a position to offer an opinion on that, not having studied it all that carefully.
I might take the opportunity to offer an opinion myself, but I think I'd like a follow-up question instead, and that is, you're aware of the judgment fund that the Department of Justice maintains, Mr. Wiesner?
Yes.
And when do you have any idea what's in the judgment fund?
No, I don't.
Does the public have access to the amount of that judgment fund, to your knowledge?
I'm not aware that they do.
Does anyone on the panel know if there is public access to the volume, the amount in the judgment fund of the Department of Justice?
Don't know.
No.
Neither, none of the witnesses do. And are each of you aware that the Department of Justice occasionally reaches into the judgment fund and pays out in a de facto class action suit? And I'm speaking specifically of the Garcia case, and I'd ask Mr. Wiesner first. Are you aware of that?
I'm not aware of that.
Okay. Any of the witnesses familiar with the Pigford Farms issue? I'm putting you all on the spot here. All right, I'll make my brief statement on that, and then I do have a follow-up question. I'll change the subject a little bit. I can see what I have broached here this morning. But my statement is this, that I watched class action lawsuits be grown out of proportion to the original claimants, out of the proportion of the original definition. I watched the Pigford Farms issue come through this Judiciary Committee in an attempt to pass a Pigford 2, which did finally pass this House, the same version did not pass the Senate. I saw Barack Obama be elected as president, and then I saw the Secretary of Agriculture, Tom Vilsack, team up with the Attorney General Holder and go negotiate with the black farmers and hand them another $1.25 billion on top of the $100 million that was authorized within the 2008 Farm Bill that was designated to be the total sum to resolve any outstanding claims on Pigford. So we've seen the executive branch go outside the directive of the Congress and reach into a slush fund of the Department of Agriculture for Pigford. We're watching them reach into this judgment fund in the Justice Department for Garcia and perhaps others. And I am very troubled by this lack of a formal oversight for de facto class action suits and actual class action lawsuits. But I would pose this question also that I promised I'd change the subject and pop this one up, and I'd start first with Mr. Reddish, and that is the term fairness was something that, well, I should actually go to Mr. Wiesner. I'm running out of time. So you use the term fairness, I know. Can you define that for me? It always confuses me when I hear that word. Marilyn and I have raised more than one child. We know there's no such thing as fair. How do you deal with that in the legal arena?
I think the important thing to me in that regard is that both sides get a fair hearing in court, that both sides have the ability to present their viewpoints, and I think that the the law providing federal court jurisdiction certainly has achieved that.
But that's not really the definition, is it, Mr. Biesner?
I think
How does the court define it? Is there a legal definition that would help someone who has a blurry understanding of this word fair? It seems to me like it's a utility word that can be used in any circumstance, and it's always unfair to the other person.
I think it's grounded in the due process clause of the Constitution, which I think underlies Rule 23. And I think the notion is that you have a procedural device here, the class action, which puts enormous power in the hands of those who are bringing the lawsuit and often invites a lot of corner cutting. And I think that in this context, the notion of fairness is to ensure that you don't get that sort of corner cutting in the lawsuit.
But there is no word fair in the Constitution.
There's what?
The word fair doesn't exist in the Constitution or any of the amendments, correct?
It doesn't exist in the Constitution, but I think in the class action context, the underpinnings of that word lie in the due process.
It is a long definition. I grant you that, and I thank you for your response, all the witnesses, and I yield back.